Hi, I'm attorney Jack Inman, and today I'm going to talk about the number one thing that I see well meaning parents do that absolutely torpedoes their custody case. So, all too often, when you have parents that are trying to co parent, you'll have one side that does something that puts the child's safety at risk, or at least potentially puts the child's safety at risk, right? Maybe that parent gets a DUI, maybe they get arrested for something. Maybe they move a significant other in a house that has a long criminal rap sheet, whatever the case may be. And you, as the other parent, look at that and you say, I'm not so sure that my kid is safe going over to that parent's house and spending the night and having unsupervised contact. That makes me very concerned, right? Comes up all the time. Sometimes it's unwarranted, but oftentimes it is warranted, right? And so the number one mistake that I see people in those situations do is they look at the other side and they acknowledge that there's a legitimate safety concern and they refuse to let the other side take their child, despite the fact that they have a parenting plan that gives that other parent visitation. Now, from your perspective, you're doing the right thing. You're protecting your child. You're making sure that the child does not go to a household where there's some kind of safety risk at play. From the court's perspective, you are violating their court order. You have an agreement that's signed by the judge that states they will have visitation with the child, and you are withholding the child from that parent. That can get you in hot water real fast unless you can show that you have a bona fide safety concern and the judge believes you 100% and the judge excuses your behavior of violating the parenting plan because the safety risk is so severe. Now, how should you approach that? Well, in Tennessee, there's this thing called an ex parte procedure. What ex parte means simply is that you have a hearing with the judge without the other party present. And that's reserved for only the most serious cases when there's a serious safety risk to the children and time is of the essence. And if you don't act immediately, there's a substantial and material risk of injury to that child. So, how do you go about getting an ex parte? Well, you need to contact an attorney first. They need to draft some paperwork. All this has to be done very fast. Then that attorney has to go get an audience with the judge. Parties are not present. You, as the petitioner, can sit in the audience if you want, but generally speaking, just the attorney goes alone. And the attorney's going to hand the judge all of these facts that you swore to under oath that should be very concerning to the court that that's going on in the other household. If it's concerning enough, the judge will sign an order right there stating that you don't have to give the kid back to the other parent until the court has a hearing on the matter to determine what's in the best interest of your child. That's how things should play out. Now, if you ignore all of that and you just withhold the child, you better believe that you're in violation of a court order and court can hold you in contempt. Is the court always going to hold you in contempt? Not necessarily. If there is a significant legitimate safety concern, even though you're violating an order, court may not hold that against you. But if you want to play it safe and if you want to do things right and you want to ensure that you are not injuring your case, then go through the proper steps, get the ex parte done, have the judge sign off on an order stating that you have permission to withhold the child. That way, the other side can't use that information against you later. Because what I've seen all too often is that parents withhold their children despite what they think are reasonable reasons for doing so. And later the judge holds that against them and they get in a whole lot of trouble. I've seen people get even jail time for doing things like this. So if you're going to do it right. And if you need help, contact my office. We walk people through this all the time, and I would be happy to talk to you and see if your case is something that we can handle. My number is 423-777-8396. Give my office a call and we'll talk to you. Hope to see you soon.